Calls case People versus Rosemary Harrell. That all of mine.
Can you take my sugar?
Yes, sir.
What you're witnessing right from the opening seconds is the courtroom shifting into procedural mode, but don't mistake that calm tone for a lack of intensity. A forensic competency evaluation being ordered is a serious turning point in any case. This isn't just paperwork. This is the court asking a fundamental question. Is the defendant even mentally capable of standing trial? That alone raises the stakes instantly, because if someone is found incompetent, the entire legal process pauses. No trial, no verdict. Everything stops until that issue is resolved. And that can dramatically change the timeline and sometimes even the outcome of a case. Now notice how quickly this moves. No drawn-out debate, no emotional argument, just a direct order from the judge. That tells you something. Either the request was uncontested, or there's enough concern already documented that the court didn't hesitate. And here's where it gets interesting for you watching. What kind of behavior or history led to this moment? Was it something the defendant said, something in their past, or something the defense strategically pushed for? Because competency evaluations aren't just legal, they're tactical. And right now, the tone is set. This courtroom isn't just deciding guilt. It's deciding whether the process itself can even begin.
Assistant Public Defender Hannah Apple appearing on behalf of Rosemary Harrell.
You're requesting competency forensic evaluation.
Correct, Your Honor. And then if we could approach.
Pardon?
If we could approach briefly.
Forensic evaluation is hereby ordered. I'll set a competency hearing for 90. June 6th. June 6th, 2024, 9 a.m. Council approach. All right, we're back on the record on this matter after a bench conference. At this time, bond will continue. And as to what we discussed, Council, you can let me know. Thank you. Right. Court calls case People versus Benny DeNovi. The singer?
Won't let me start the video for some reason.
Okay. Assistant Public Defender Hannah Apple appearing on behalf of Mr. DeNovi.
Is that true?
And I'm Special Assistant Attorney General Mitchell Wood for the people. I don't know that we have a case number.
Good morning, Your Honor. Eric Julian appearing on behalf of Austin Bryan, who is present. Can you state your name, please?
Austin Bryan, in all four cases.
Yes, Your Honor, in all four cases. And I do have a preliminary exam waiver in all four cases. Oh, I'm sorry.
On all four?
Yes, Your Honor. I did write all four case numbers on it.
All right. Sir, you're waiving your right to have a preliminary examination in all of these matters?
Yes, Your Honor.
This right here is a critical legal decision, and one that most viewers don't fully appreciate. The defendant is waiving the preliminary examination. Now let's break that down clearly. A preliminary exam is where the prosecution has to prove there's probable cause. Basically enough evidence to justify moving the case forward. It's not about guilt yet, just whether the case holds weight. By waiving that right, the defendant is essentially saying, we're skipping that step. Let's go straight to circuit court. Why would someone do that? There are usually two reasons. Either the evidence is strong enough that fighting it here won't help, or the defense wants to move faster to negotiate, strategize, or control the narrative at a higher level court. But here's the trade-off. By skipping this hearing, you lose the chance to challenge the prosecution's case early. No cross-examination of witnesses, no preview of their strategy. So now the question becomes, was this a smart move or a risky shortcut? Because once you move forward without testing the evidence, you're stepping into deeper water, and there's no easy way back.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you won't have that hearing and that any of these hearings, and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right in these matters. Preliminary examination having been waived, defendant is bound over to circuit court on all counts with any misdemeanors following.
Yes, Your Honor. We would not receive the information. He was criminal rating and stands mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set for
March 19th at 1:30 before Judge Simpson.
March 19, 2024, 1:30. Bond will continue.
Thank you very much, Your Honor.
Thank you. And good. I've got, who do I have? There. I don't have a file.
There you go.
Court calls the case People versus Patrick Connolly. Two cases.
Attorney Morgan Barroso on behalf of the people. No counsel with me, please.
All right. Sir, your name?
Patrick Conley, sir.
Okay. You went through an arraignment on these?
Not quite sure. I think I'm here for a bond arraignment.
Are these set for arraignment?
I'm not real sure.
Hold on.
I think it was for a bond arraignment.
For Judge Fresh Hour and what?
Last week.
Good day, Mr. Brown. How are you?
Okay, and so what happened with?
I was there.
That's why my files are messed up. Okay.
So I represent him with some misdemeanors, and then prosecutor dismissed the misdemeanors, filed felonies against him. And then he was supposed to, this was on Tuesday last week, but Thursday, he didn't make the cut for the PCC. So I guess he's here for arraignment on the new felonies. Like,
Well, hold on a second now, because you have,
It was already given conditions.
okay. I don't know.
Should be. Yeah, he was already arraigned because he got.
He was already arraigned on these. However, what we don't have is they don't have counsel appointed, but your understanding, Mr. Brown, was that the PD was handling these?
well,
Or, pardon?
I can.
Well, you want counsel, sir?
I would like to know why I'm here for one.
Now this is where the courtroom energy shifts, from structured procedure to visible confusion. The defendant is openly questioning why he's even in court. That's not a great position to be in, because it signals a breakdown somewhere. Communication, legal representation, or understanding of the process. And notice the judge's reaction. Immediate interruption, trying to regain control and clarity. That's because confusion in court slows everything down. And judges do not like inefficiency. What's happening here is a mix-up between different hearings, bond, arraignment, possibly multiple cases. And that's dangerous territory for a defendant, because when you don't fully understand your situation, you can't make informed decisions. Also, the mention of a young lady from the public defender's office. That vagueness tells you the defendant isn't fully anchored in his legal support system, and that raises a bigger issue. How prepared is he really? Because in court, clarity is power, and right now, he doesn't have it.
I thought it was under the, I spoke
Okay.
to a lawyer last week. They were set up a bond hearing for me for.
Let me
Yes, sir.
Let me stop you real quick. When you say you spoke with a lawyer, do you know who that was? Was it somebody from the public defender's office?
Yes, sir, it was.
Okay,
It was a young lady.
okay, that
And-
narrows
and I
it down
think
to
with
about
Miss-
30,
Yeah.
but go ahead.
With Judge Fink, they were set up a bond reduction hearing of sorts. I thought that was why I was coming in. For today, I'm not, and maybe get released.
So hold on, were you before Magistrate Fink or before Judge Fresh Hour?
I was before Magistrate Fink, but I was arrested, I was detained
Okay.
through Miss, who you said, the young lady from Saline. The judge from Saline, I can't pronounce it, I'm sorry.
I'll tell Chief Judge Fresh Hour. You
But I
told her
was
that.
detained then, but I had went and spoke to a public defendant from your office about a reduction in.
I don't have any
bond.
public defenders in my office
Yeah,
because I don't let them in. Okay, I'm trying to figure out, sir, there were misdemeanor cases
Yes, sir.
that you had out in Saline
Yes,
at some point,
yes, sir.
correct? My understanding from what Mr. Brown just said is those were dismissed.
And they, yep,
And then what my file looks like is that you were arraigned then on new felony charge
yes, sir, correct.
at that time.
Yes, sir.
All right. And at that time, you were, I'm presuming at the arraignment, you were apprised of what the charges were against you.
Yes, sir.
Okay. So what I have, so that you understand, is I have one case that is noted, actually both are noted as a reauthorization. I have, in one case, that being case 0274, operating with a high BAC third offense, and driving while license suspended second or subsequent offense.
I had no.
So hold on, so that you're clear, that offense date is May 29th of 2020. Okay, that's one case. The other case that I have is operating with a high BAC third offense also, and then driving while license suspended, denied, and or revoked second or subsequent offense, as well as, I think I've got one more charge on that one. I got, okay, and then also on that one, a misdemeanor charge of operating a motor vehicle without security, and another misdemeanor charge of operating an unregistered vehicle. That's on the case that ends in 0273. Okay, that offense date is September 24th of 2022. Okay, you were apprised that that's what you're being charged with, sir?
I suppose. I wasn't aware of the suspended. There was no added charges to any of the other offenses, the two blood alcohol offenses. I wasn't aware of any additional charges on that other than just the high blood alcohol.
Okay, so just so that you're clear, there are two high BAC third offenses, two felony charges.
Yes.
Okay.
This is where the seriousness of the charges becomes crystal clear. Two high BAC third offenses. Let's break that down simply. A high BAC means the blood alcohol level is significantly above the legal limit. And a third offense? That's where things escalate from minor trouble to major legal consequences. We're no longer talking about a mistake. We're talking about a pattern, and the judge carefully lays out each charge, each date, each additional offense. Driving on a suspended license, no insurance, unregistered vehicle. This isn't one issue. It's a stack of violations building on top of each other. That stacking effect is critical, because in court, repeated behavior often matters more than a single incident. It shapes how the judge views risk, responsibility, and credibility. And here's the key takeaway. By the time all charges are listed, the narrative isn't just about driving, it's about disregard for legal boundaries. So now ask yourself, if you were the judge hearing this pattern, would you be lenient?
With different offense dates, so there are two
Yes,
of
sir.
those.
Yep.
There are two charges on those same dates of driving while license suspended second or subsequent offense. Okay, that's a 1 year misdemeanor.
Yes, sir.
Okay, and then on the newer case, the one occurring in 2022, you have operating without security, basically operating a vehicle without insurance.
Yes, sir.
And then operating an unregistered vehicle. Both of those are misdemeanor charges.
Yes, sir.
Okay, are you clear on what you're charged with?
Yes, sir.
Okay. Now, because I have you as having been arraigned, and that you were not given, I don't have counsel appoint or set for you. So my first question to you, now understanding the charges, do you wish to be represented by an attorney?
Yes.
Okay, these are public defender cases.
Thank you, Your Honor. Lauren Brown, the other Mr. Brown, the less handsome one, appearing on.
That is so true. But go ahead.
Your Honor, what we're going to ask for is a 2-week adjournment, then be asked to be allowed to address bond.
Okay. So I'll adjourn this out 2 weeks, but before you get to your bond argument on it, so this will be adjourned to March 21st, 2024,
Yeah, they're at
9 a.m.
$50,000.
Here it is, the number that changes everything for the defendant. $50,000 bond, 10%. Let's translate that. He doesn't need the full $50,000, but he does need $5,000 to get out. And for many people, that's still a massive barrier. Bond isn't just about money, it's about risk assessment. The court is asking, can we trust this person to show up? And based on what we've heard so far, multiple offenses, confusion, prior issues, that number reflects concern. Now here's the tension. The defense is about to argue for reduction, likely pointing to employment, stability, willingness to comply. But the prosecution, they're going to focus on history, patterns, and risk. And this is where courtroom storytelling comes into play. Each side is building a narrative, one of rehabilitation versus one of risk. So watch closely. Because this next stretch isn't just about numbers. It's about which story the judge believes.
10%.
So now at some point, and now this gets to what Mr. Connolly was, I think, talking about. At some point then, after you saw Judge Freshour,
Yes, sir.
you then saw Magistrate Fink. Is that right?
Yes, sir.
Okay, at some point, you're and I'm just going by what you're saying because I don't see an indication in the file, but I'm trying to figure this out as we're going through it. You believe that you were here for a bond?
Yes, I
Hearing?
believe the young lady's first name was Natalie.
Oh,
He actually has a DV case with Judge Freshour.
And that's on the,
Violation hearing on the 14th.
oh,
and that's Friday. Next week.
so but the whole bond thing wasn't on these cases. It's on another case.
I'm not even real sure.
Okay, so
Because-
he has a bond hearing on that one on,
March 14th with Judge Freshour.
okay. So you do have a bond hearing. You probably did see the magistrate regarding that bond hearing. That is a separate misdemeanor case, which you'll be heard before Judge Freshour, according to my staff, on the 14th.
Okay.
Okay?
I think I have something on the 12th as well.
Wow.
That's they threw
Where?
that at me at one time. Like
No, that's okay. I'm just trying to figure out
I thought the domestic one was actually good.
that's on the 14th.
Yeah.
We figured that out.
I had something that was rained over from a rainy day we had freezing rain and the court was canceled. They pushed it to the 12th.
Do you know?
But
No, it's okay.
Yeah.
Well,
I'm still trying to make sense.
because we had, the 12th was also exam date. So was he set for an exam and that got pushed over?
Your Honor, if I may,
Please.
the only three cases he has right now are the two that are up for today and the DV that he has in front of Judge Freshour. The DV he has in front of Judge Freshour, he has a $1,000 10% bond in that case because he failed to appear. That is up again on March 13th. The two cases in front of you today are reauthorizations of cases that were previously charged as misdemeanors. They were reauthorized by APA McDuffie because he has had multiple community correction violations before completely absconding in 2022 and early in 2023. My understanding is that in charging those misdemeanors, the charging APA missed the prior offenses, which would have brought this into the felony level. So due to the combination of the circumstances, due to his absconding and community corrections violations, as well as discovering the missed priors, they were reauthorized as felonies.
This is a turning point, and it's not subtle. Charges that were once misdemeanors are now reauthorized as felonies. That's a massive escalation, and the reason? Prior offenses and community corrections violations. In simple terms, the system gave chances before, and now it's tightening the response. The prosecution lays it out clearly. Missed violations, repeated issues, patterns of non-compliance. This isn't being treated as a first-time mistake anymore. This is being framed as someone who didn't follow the rules even after intervention. And once something crosses into felony territory, everything changes. The potential penalties increase. The long-term consequences become more severe, and the court's tolerance drops significantly. Also notice the added layer: contact with a victim despite restrictions. That's not just a violation, that's a direct challenge to court authority. At this point, the narrative is shifting heavily against the defendant. And the question becomes unavoidable. How much patience does the court have left?
I do also know that Your Honor is not overseeing the DV misdemeanor in 1484, but if the court could remind him that he is not supposed to have contact with the victim in that case, that would be greatly appreciated, because there has been jail calls there as well.
Okay. All right. So you said his DV is on the 13th before Judge Fresher. 14th in 4, and that's what we just told him, I think. Okay.
There's nothing on the 12th.
There's nothing on the 12th that we see.
Okay.
Got that?
Yes, sir.
Okay. So you wanted to address bond. Sir, well, let me just say this. That's not my case. It's Judge Freshour's case, but I'm sure as a condition of the DV case, you're not to have contact with the alleged victim in that
Yes, sir.
case. That means you cannot make those calls if there are calls being made from the jail.
Absolutely, sir.
You understand
Yes,
that?
sir.
That contact is either directly or indirectly.
Yep.
You can't have somebody call on your behalf or anything along those lines.
Yes, sir. Yeah.
Understood?
Yes, sir.
All right, thank you.
If I could make a note to the court about that. No.
Well, you probably
Never
don't
mind, I'll
want to,
speak to
because
him.
if I have to go grab the file, things are gonna get
No, sir.
bad.
That's
All right. Mr. Brown,
So the bonds currently set in the 2 high blood alcohols are 10,000 notes.
what do
My
you,
understanding is that each file up today, it is 10,000, 10%. So
Or 10%.
I do believe that we requested 50,000 unsecured appearance bond. I do believe that bond is appropriate. Cash surety.
10,000 cash surety on both?
Yes.
Okay.
Oh, Your Honor, the bond set at 10,000 cash surety. My client is unable to post that at this time.
if it's 10%.
This is the defense finally stepping in with a human angle, and this is where courtroom narratives really collide. On one side, you have the prosecution painting a picture of repeated violations, missed obligations, and risk. On the other side, the defense is trying to reframe the defendant as someone who can still be stabilized, someone with an address, job prospects, and a path forward. Notice the strategy: employment, responsibility, future compliance. These are classic mitigation arguments. The defense isn't denying the past, they're trying to sell the future. But here's the problem. Courts don't just evaluate promises, they evaluate patterns. And right now, the pattern on record isn't helping. The mention of treatment is also important. It signals acknowledgement of a deeper issue, likely substance-related. That can work in the defendant's favor if the court believes there's genuine intent to change. But here's the key tension: should the court take that risk? Because every bond decision is a gamble. And the judge has to decide, is this someone who's ready to turn things around, or someone who's already shown they won't?
He has an address at 167 in Saline, Michigan, to which, if he were to make bond, be able to go to that address. He was in the course, he had 2 job interviews when these cases came up. He'd like to get that back on track so that he can become employed and become a contributing citizen. If, in fact, there will be a necessity for some sort of alcohol treatment or something moving forward, he would be in a position to pay for those things. He's asking for a PR in this case. He's asking that the court allow him 10% privilege. Will return to all future court dates. He will follow the strictures of the court.
Okay, well.
If I need to make a couple of my mother will be taking my phone calls from my sister.
So, Your Honor, also he would ask that if the court would consider sober link, that would be a good way of keeping track of him, sure that he is following at least the notion that he not have alcohol while he's out.
Okay, two things that I'm concerned about is one, there was an indication that he didn't comply with the directions of community correction previously. I don't know much about that, but that was brought up. And while the word absconded was used, there, it seems to me, a period in time which he didn't bring himself before the court.
This is where the prosecution lands a heavy hit. And it's not just about facts, it's about credibility. The word absconded carries weight. It means the defendant didn't just slip up. He disappeared from the system. Missed tests, positive drug results, failure to appear. This is exactly the kind of history that makes judges cautious. And notice how detailed the record is. 5 positive cocaine tests, 7 missed tests, a timeline of violations. This isn't vague, it's documented behavior. From a legal standpoint, this shifts the conversation completely. It's no longer about whether the defendant can comply, it's about whether he will. And that distinction matters, because courts are far more concerned with reliability than intention. Now add in a revoked license for 20 years. That's not a short-term issue. That's a long-standing pattern of disregard. At this point, the prosecution isn't just arguing against bond reduction. They're building a case that supervision itself might not work. So here's the question. If someone has already been given multiple chances, how many more should they get?
Ms. Barroso.
That is correct. My notes from Ms. McDuffie indicate that when this case was reauthorized, the defendant was in bond violation and in bench warrant status. According to Ms. McDuffie, the community corrections violations include 5 positive tests for cocaine before he completely absconded, missing 7 tests between December 2022 and January of 2023. My understanding is that his license has been revoked for at least the last 20 years. And has, like I said, he has a history of failing to appear. So I'm very concerned. I also do want to note that the data master results from at least one, or from one of the, I don't have them on the case number ending in 0273, but in the 0274 file was a 0.2 and a 0.19. So I don't think that a sober link would necessarily be sufficient in this case. If the court was inclined to modify bond, I would be asking at least for a scram tether.
I'd be willing to do that.
He'd be willing to do that, Your Honor.
Sure he would. I think the difficulty, the concern that I'm having, I think we can figure out the alcohol component of it. I'm worried about the cocaine usage, which I can't monitor from afar with a sober link or a tether. He would have to appear at community corrections, but then that goes into the issue of him disappearing and not bringing himself before the court, which also causes the court a bit of a problem.
I think so. I think twice a week to test. That's a question.
Is there anything else, Mr. Brown? I know you.
He would be willing to come into community corrections and test twice a week, Your Honor.
Well, he did that the last time. My understanding was positive, and then poof, we didn't see him. So here's what I'll do at this juncture and allow everybody to get all of their information straight with them. I'm going to continue to defendant's bond as is right now. I don't have a problem either by written motion or otherwise addressing it then on the 21st, when everybody has everything that they can place in front of me, one way or another. So at this point, bond will continue.
And there it is. The decision lands. Bond stays exactly where it is. No reduction, no adjustment, no second chance, at least not today. But listen carefully to how the judge frames it. This isn't a permanent shutdown, it's a delay. The judge is essentially saying, come back with stronger information and we'll revisit this. That's a strategic move. It keeps control in the court's hands while giving the defense a narrow window to rebuild their argument. But make no mistake, this is a loss for the defense in this moment, because every failed attempt to reduce bond reinforces the perception of risk. Also, notice the judge's concern isn't just alcohol, it's cocaine use and compliance. That's a harder problem to manage with standard monitoring tools. So what you're seeing here is the court balancing two things: opportunity versus accountability. And right now, accountability is winning.
Thank you.
Thank you.
So
I don't know what they did because there's a note that they moved that. I don't know what they did.
Who is present with me, Your Honor?
Your name, sir?
Terrell Daniels.
Thank you.
Your Honor, we are requesting a preliminary examination in this case.
Discovery complete.
I believe it is, yes.
People have their witnesses available on the 19th.
I believe so, Your Honor.
Preliminary examination in person, March 19th, 2024, 9 a.m. before Judge Perry. Bond will continue. Yeah.
I wanted to ask the court to remind the defendant that he's not to have contact with the victim. He called her twice, and it's understanding he hasn't talked about that with counsel yet. So we wanted the court to remind him he's not to have contact with her.
So he's contacted the victim twice.
Yes, Your Honor.
You know,
No, Your Honor, I was just informed about that by Ms. Barroso today. I'm not certain of the content of those. I respectfully ask that at the most, for purposes of today, you admonish him, or certainly
actually,
now,
here's
please
what we're gonna do.
remind-
He's got an exam coming up on the 19th. I'm revoking his privileges. You can bring it up before Judge Perry. You have to get him back. Thank you.
This moment escalates quickly, and it shows how seriously the court treats violations involving victims. The issue here isn't complicated. The defendant was told not to have contact with the victim, and there are indications that contact still happened. That's a direct breach of court orders, and judges do not tolerate that. So what happens? Immediate consequence. Privileges revoked. No warning, no drawn-out debate, just action. And this is important for viewers to understand. When it comes to victim protection, courts operate with zero flexibility. Even potential violations are treated seriously because the risk is too high. Also notice the defense's reaction: uncertainty, lack of full information. That's a tough position, because when you can't clearly defend your client's behavior, the court leans toward enforcement. This moment reinforces something critical. Courtroom rules aren't suggestions. They are conditions. And when those conditions are broken, the response is swift and decisive.
Court calls the case, People versus Bernard Brock.
Andrew Banis, Assistant Public Defender, with on behalf of Mr. Brock, who is present.
Your name, sir? Bernard Brock. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right, the plea form indicates that the defendant will be pleading guilty to an added count 2 of larceny, 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. There also is indicated there is no objection to HIDA.
That is our understanding, and I have discussed that with my client a few times, and also this morning, and I believe he wished to proceed.
Yes. Is that? Thank you. May I have him sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Bernard Brock. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of larceny 200 to 1,000. Is that correct?
Yes.
That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs.
Now we shift into a completely different type of courtroom moment, a plea. And this is where things become very structured, very precise. The judge is walking the defendant through every consequence, step by step. Maximum penalties, fines, rights being waived, nothing is left unclear. This process is designed to ensure one thing, that the plea is knowing and voluntary. Because once a guilty plea is entered, there's no trial, no jury, no second chance to argue innocence. Notice how the judge repeatedly confirms understanding. That's not just formality, it's protection. It ensures the plea can't later be challenged as uninformed or coerced. Also important, the sentencing will be handled by a different judge. That adds another layer of uncertainty for the defendant. So while this moment feels calm compared to earlier tension, it's actually one of the most final decisions a defendant can make. A plea isn't just an admission, it's a turning point that locks in the direction of the case.
The fine could be increased to 3 times the value of the property, which is the subject matter of the theft or larceny. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
This is what we reviewed earlier today.
I'm aware.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On December 13, 2021, at the location of 6405 Jackson Road, Scioto Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty of this offense?
So basically, I purchased goods with intentions of not giving it back.
Yeah. Would you like me to voir dire or no?
Please, because that didn't make that a crime.
Did you, and that location was a Menard store, right?
Yes,
That
correct.
was open to the public at the time.
Yes,
And did you take lumber without paying for it and without the owner's consent?
yes,
And at some point that lumber was moved, there was some movement of it, right, into a U-Haul truck?
yes,
I'm going to the larceny. And at the time you took that property, you did not intend to give it back to the owner, correct?
yes, correct.
You
So
have,
you took lumber from Menards, right? And you moved it off of the property?
I didn't move it off the property.
So in some way you concealed it from the owner?
Yes,
This exchange is crucial because it establishes the factual basis of the crime. The judge isn't just accepting the plea blindly, he's making the defendant explain, in his own words, what happened. And more importantly, how it meets the definition of the offense. At first, the explanation is weak. I purchased goods. That doesn't clearly establish theft, and the judge immediately catches it. So he reframes the question, guiding the defendant toward clarity. Did you take the property? Did you move it? Did you intend not to pay? And eventually the key elements fall into place: taking, concealment, intent. That's what transforms a vague statement into a legally valid admission. This is precision at work, because without that clear admission, the plea could fall apart. So what you're seeing here is the court ensuring the story aligns perfectly with the law. No ambiguity, no gaps, just a clean, complete acknowledgement of the crime.
In the U-Haul,
yes,
is that correct?
correct.
And you didn't intend to pay for that property, correct?
No.
Okay, you intended to take it away from there, right?
Yes.
All right, but was the value of that property in excess of $200?
you know, well, my advice is based on the discovery, yes, it was, and we would stipulate to that.
You'd stipulate to its value being in excess of $200?
Yes, Your Honor.
The misdemeanor that was offered in place of the felony is larceny of property of a value at least 200.
2,000.
2,000, yeah.
Yes.
And do you agree that?
So are you stipulating to the 200?
Yes. Yes.
Yes.
Honor.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
April 1st at 9 a.m. before Judge Fresh Hour.
April 1st, 2024, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you. Send you that in.
Court does call the case of the people versus Deja Foster.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Foster. State your name.
Deja Foster.
Thank you.
Your Honor, we are still scheduled for a competency review hearing. We have not received.
I have no report either at this point.
Well, Your Honor, we ask for a 3-week adjournment. Hopefully the report will be complete.
All right, what I'm trying to do with these, because of the delays that are happening, I try to put them out about 30 days and then we'll move it up if we have to. So,
April
or,
4th. Yes.
so I'll adjourn comp review hearing to April 4th, 2024, 9 a.m. Bond will continue.
Thank you.
Thank you.
As this courtroom session wraps up, what stands out isn't just one case, but the pattern across all of them. You've seen competency evaluations that pause justice before it begins, defendants waiving critical rights to move cases forward, charges escalating from misdemeanors to felonies due to repeated violations, and bond decisions shaped not by promises, but by history. You've also seen how quickly things can shift. Privileges revoked over a single violation, pleas locking in outcomes, and judges constantly balancing fairness with accountability. And at the center of it all is one consistent theme. The courtroom doesn't just react to what happened once, it responds to patterns. Behavior over time. Compliance versus defiance. Responsibility versus risk. Every decision you saw today, from bond to plea to privilege, was built on that foundation. So now it comes down to perspective. Are these outcomes the result of a system doing its job, or individuals failing to meet the chances they were given? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.